Hi, everyone. My name is Ty Adams, and I want to welcome you to TRA Marketplace 2020. Thank you for joining us today for Employment Practice Liability Insurance. Please feel free to engage throughout by asking questions using the Q&A window below. Without further delay, I'm excited to introduce our Big Ben stage sponsor, Texas Mutual.
In response to the pandemic, Texas Mutual will distribute $330 million in dividends to eligible policyholders 2 months ahead of schedule. We're also sending $2 million to nonprofits on the front lines of the COVID-19 effort. Better days are coming, but in the meantime, we'll be on the job helping Texas businesses. To learn how dividends are supporting employers in this time of need, go to texasmutual.com/dividends.
To kick this session off, because I don't want to delay time, we are super excited. I'd like to introduce our speaker, Miss Lori Wheeler with Marsh Wortham, and I'm going to allow Miss Lori to tell you a little more about herself. Lori.
Thanks, Ty. I appreciate the invite and speaking again this year. Sorry we can't do it in person, but this is we'll make do with this. My background is I've been either an insurance underwriter or an insurance broker of specifically employment practices liability insurance for about 30 years, all here in Houston and the state of Texas. And the type of insureds I work with are publicly traded companies, privately held companies, nonprofits, but always just specialized in the products that are similar to employment practices. So that is my background. I am currently with Marsh, heading up a group that basically places lots of private company and nonprofit employment practices. And so let me pull up my presentation and we will get this show on the road. 2 seconds. And here we go. Okay, can everyone see the presentation now?
Yes.
All right, so we're going to talk about employment practices liability exposure now that we're in the pandemic with COVID-19 and how it impacts us. Even before restaurants were back open for business, the plaintiff's attorneys were already gearing up to sue employers over a variety of claims. As an employer, unfortunately, you are going to be a target for employment practices litigation arising from COVID-19. And specifically, I've tried to gear this to exposures you're going to face as a Texas restaurant owner and what types of litigation you specifically might be seeing due to COVID. So let's look at what type of potential claims could be potentially filed against you. Of course, there's always going to be violations of the Family Medical Leave Act, the Americans with Disability Act, and now we have new laws we can be concerned about as employers, specifically the Families First Coronavirus Act. Discrimination claims are quite prevalent right now as we are having to furlough or lay off our staff. We're getting claims that are revolving around how you made the determination of who was going to be furloughed, who was going to be laid off, and then more importantly, how did you decide who you were going to bring back once you got reopened? And those claims are prevalent. I'm going to show you some numbers specific to Texas around discrimination claims. Hostile work environment claims are quite interesting, but as you can imagine, if an employee develops the virus and other employees treat them differently upon their return to the work environment, you could potentially get hostile work environment claims. And you can imagine how other employees feel if you've had COVID and now you're standing next to them, you know, cooking or washing dishes or waiting on guests. Class action claims, we've not seen any yet, but it is something we need to consider. If you are subject to the WARN Act, which is the act that requires that you give people notice before you lay them off, we're all subject to COBRA and all subject to OSHA. So if there are any class action claims around how you treat your entire staff as respects those federal laws, there's the potential for claims. Retaliation and whistleblower claims are going to be a factor. Retaliation claims are the most prevalent claims that the EEOC sees, but as you can imagine, these claims are extremely hard to defend, because if you terminate an employee after they've engaged in a protected activity, the first thing their employment attorney is going to tell them is you've been retaliated against. So what's a protected activity? Well, that's, you can look at it from a whistleblower standpoint. Did the employee lodge a complaint because you had an unsafe workplace environment? You were violating an executive order around COVID precautions. And then you let that employee go after they blew the whistle on you. That is almost 100% going to generate a retaliation claim from that terminated employee. If you have an employee that engaged in a protected activity as part of the new laws, the Family First laws, one of the activities they can do is taking leave. And if you have an employee who takes leave to care for their children who are no longer in school or daycare, and you treat that employee differently when they come back to work, they can say they are being retaliated against. If you have wait staff who had to take time off to take care of children, and now their hours in the workplace have been reduced, did you discriminate against them because they have children? Are you retaliating against them? And if they are terminated after they've engaged in that protected activity, here comes a very hard claim to defend when you get into court. One of the other issues that I know a lot of the insurance companies are very concerned about is now that we are all working remotely and we're not in formal workplace settings, and this is more for your administrative staff than your staff in the actual restaurants. But now that we're not in an office setting where HR is in the office next to us, and we're in much more relaxed environments, is there going to be an increase in sexual harassment claims? Is there going to be an increase in a little more of the workplace bullying? Comments made to each other, being more relaxed and in this setting Are we going to get more of those type claims, especially the sexual harassment claims? And our insurance companies are quite concerned about that. So let's look at Texas in particular. So the state of Texas, as of August the 11th, and according to Fisher Phillips, a law firm, says that we have had 36 complaints filed in the state that were COVID related. And the leading allegation of those 36 complaints is employment discrimination. So here's how the Texas COVID litigation has broken down so far. So basically, I would look at this from March till today. We've had 7 employment discrimination claims, 6 claims regarding remote work or leave conflicts. We've had 5 wage and hour claims. We've had 4 non-compete claims. Interestingly enough, we've had 3 wrongful death claims in the state of Texas. We've had 2 unsafe workplace claims, and I'm going to show one that's here in Texas specific to a restaurant. We've had a WARN Act claim, breach of contract, and then wrongful discharge, of course. The wrongful discharge claims, the employment practices firm of Fisher Phillips believes is going to jump up here in the next coming months. Let's look at the Family First Coronavirus Response Act first, just to understand this new law. This has been developed in the last few months, so let's at least get a little familiar with it. There are 2 key provisions for employers who have fewer than 500 employees. One is it creates limited paid sick leave, and it amends the Family Medical Leave Act to expand that act to provide some of the benefits to employees who have to stay home for COVID-related child care issues. So this act went into effect April 1st, and it is right now scheduled to remain in place until December 31st. There are significant penalties associated with this act. So if there's an unlawful termination that's treated as discriminatory under the Fair Labor Standards Act, or if you fail to provide the emergency paid sick leave, you could be faced with a fine up to $10,000, imprisonment up to 6 months. That is just unbelievable to me. Imprisonment up to 6 months. And then you would have to pay damages, which could include liquidated damages. And then you would also have to pay attorney's fees and cost for the person who is suing you. Under the Expanded Family Medical Leave Act, the penalties remain the same there. That's the same that's under the FMLA Act. So there's potential back pay, front pay, and then those liquidated damages, and then again, paying the attorney's fees for the individual who has sued you. Both companies and individuals can be sued by private individuals or by the Department of Labor. There is an exception to that if you don't meet the normal FMLA employer test, the individual cannot sue you, but the Department of Labor still can. So no one is immune to the Department of Labor potentially suing you under the Families First Act. So what are some of the claims that could potentially come out of this act? Basically, it could be a failure on your part to recognize that you are subject to the act and you improperly calculate your number of employees. So let's say you have several entities under your legal structure that hold and hire employees, that you make your employees payments through these entities. If you feel that those entities should not be combined, or that you are an integrated employer and you are above the 500 employee count, and the Department of Labor comes in and potentially says, no, those are not combinable, and you are not above 500 employees, you should be paying these benefits. So make sure you are properly calculating your number of employees, and you may want to talk to an outside attorney about that. Some of the other claims are determining if the employees are eligible to telecommute to work while caring for their children, and knowing what employees are eligible for that and what employees aren't. There's also claims that we're worried about on how you calculate the correct amount of leave and or pay that can be provided to your employees under this act. And then if an employee has intermittent leave, so an employee's child care is opened back up, but then one of the children at the daycare gets COVID, so they close it back down. So you have an employee who was able to come to work, but then is unable to come because daycare closes down. How do you calculate the allowance under Family First for them having intermittent leave if they have to be in the workplace, out of the workplace, and telecommute, and then back in? So these are all potential issues. We haven't seen the claims yet. This is brand new, this is a brand new federal law. So, but these are areas that are potential claims areas you need to be prepared for. Again, the interesting thing about employment practices law is you do not have to be guilty to be sued. And employment practices insurance is here to defend you when these allegations are made against you. And so let's look at some of the other areas that we've seen the litigation already filed. So here's a specific claim from a Texas restaurant. And it's a discrimination claim, which we've already seen is the highest number of claims brought against us. So I'm just going to summarize this. Y'all can read it for your own use. But this individual was a restaurant cook who alleges she was prohibited from working because she wanted to wear a protective mask. The restaurant employer had made the determination that their Texas locations were not required to wear masks, the workers weren't, and the guests coming to the restaurant also were not required to wear masks. And they actually made the statement, if you are concerned about your well-being with respect to masks not being worn, we hope you will join us at a later date. And they made that statement to their staff as well as their guests. So this employee refused to come to the work environment where she was not allowed to wear a mask. And she alleges that the restaurant reduced her hours because she wanted to wear a mask. A county judge agreed with that employee and granted her a 14-day temporary restraining order. And she was allowed to come back to work and wear her mask while working. Interestingly enough, the employer tried to get the case removed to federal court, only to have it remanded right back to the county judge, and he is now considering a permanent injunction against that employer. So this is brand new litigation here in Texas, so that's something we can keep an eye on. But I'm just surprised I would have thought it was an employee wanting to come back and not wear a mask, but this is the polar opposite. And I would imagine that that employer might have changed their policy and doesn't mind people wearing a mask in the workplace environment. Discrimination claims, they come in all kinds of allegations, but here, now these are not Texas specific, but you can see how they could work in any state in our country. We had a COVID-related RIF, and the employee is saying that the employer targeted African-American employees for that RIF. So it was a COVID-related RIF, but in this case, apparently African-American employees were terminated at a much higher frequency than other classes of individuals. Discrimination claim currently working. The second case we have here is an employee alleging age discrimination. We had a furlough situation due to COVID. He is alleging that they are bringing back younger employees into the workplace and that they terminated his employment because of his age and his higher salary. So we have an age discrimination claim working here. The last case is a claim where the individual is alleging multiple areas that he's been discriminated against. Race, national origin, he's bringing in a retaliation allegation, and he is saying that those were the reasons that he was terminated during the COVID-related terminations. The most important things here that the guys at Fisher Phillips want to point out to employees is you have to be extremely careful in how you set up your underlying criteria for selecting your employees who are going to be impacted by a layoff or a furlough or a RIF. And that whatever that criteria is, a plaintiff's attorney is going to discover it, and it is going to be fully discoverable. So for that reason, your selection criteria has to be objective and it has to be measurable, either on that employee's production or whatever performance metrics you have in place. But please note, whatever criteria you have, a plaintiff's attorney is going to expose that in the courts when you go in to defend yourself. The second thing that employment attorneys are telling us is that you should ensure that whatever performance metrics there are being applied fairly and consistently across all of your supervisors. Doing so is going to limit any viability of discrimination or retaliation claims and further demonstrate that you're being fair and consistent with how you are putting your employment practices, policies, and procedures to work. So there's discrimination. Now let's look at wage and hour. So to give you a background, wage and hour claims fall under the Federal Labor Standards Act. And that act basically requires that employers pay employees for all time worked. You either get paid a minimum wage for the first 40 hours, and then you get, overtime for any time over 40 hours. Okay, we have an issue now that employees are potentially engaging in pre-work or post-work activities. And is that considered working under the Fair Labor Standards Act? That act requires you to compensate employees for principal activities, which are defined as activities that constitute integral and indispensable parts of the employee's principal activities. So if you are requiring an employee to put on protective equipment, if you are requiring an employee to have temperatures taken, if you are requiring employees to fill out daily health screen forms that must be emailed to supervisors before they can come into the office, is that pre-work activity considered working under the Fair Labor Standards Act, and do they need to be compensated for that time? We don't have much guidance on this right now. So again, I suggest you talk to outside employment attorneys to find out what their advice is on if you require any pre or post work activity specific to COVID, and if it's going to fall under a paid wage time. One of the really important concerns that I want to point out to our restaurant owners is, and I'll tell you, all of our insurance company underwriters are very concerned about this. A typical waitstaff employee gets paid their $2.13 base pay plus tips in a normal environment. But now, due to COVID, with our dining rooms closed, excuse me, or with limited dine-in services where the tips have been reduced, have you adjusted that minimum pay from $2.13? And have you adjusted it to minimum wage? I'll tell you, many underwriters are concerned about how you are treating this. And again, I suggest you really talk to outside counsel about if you need to make any adjustments on that minimum salary wage. Wrongful death claims, again, we've had 3 of these here in Texas. And I'm not going to go through this whole slide because you'll have access to these slides after the seminar. But essentially, this is Fisher-Phillips guidelines on how to handle COVID potential wrong situations. Number 1, make sure you're following the CDC's guidelines on how to do social distancing in the workplace, when to quarantine employees who've had exposure to the virus, how utilize OSHA's guidelines as well, educate your employees, engage with them, make sure they know you are taking every measure to try to keep them protected, that you're going to try to respect their rights to privacy and confidentiality while staying aware of their health situation. You need to constantly remind them to seek medical attention. You should probably check in with anyone who has developed COVID. Inform your employees when other employees come down with the virus. Make sure everyone is aware if there's been a potential exposure. And then lastly, just stay on top of the evolving guidelines that are coming out of the federal agencies, the Department of Labor, CDC, and OSHA. Just make sure you're very well educated. One of the things I will tell you is if you do buy an employment practices liability policy from an insurance company, there is a very good chance that that insurance company has given you access to employment attorneys at no charge. Look at your employment practices policy and see if there is a brochure or a flyer attached to that policy that gives you access to counseling and guidance from an employment practices attorney. It normally will give you a password. You can go online and go to that employment counsel's website and easily log in and get access to their COVID-related guidelines. And you can call a 1-800 number normally, discuss your particular situation, and they will give you free legal advice. Use that. So let's talk about what an employment practices policy is, because we've only got a few minutes, and I'll speed this up really quickly.
Yes, Lori, if you could kind of speed it up, I may be able to give you one more minute. I have to,
Right.
yeah, I may have about one more minute. All of the slides, everything will be made available. There's so much information to be covered regarding a lot of this. Majority of it, we'll be able to get to them once you send it over to us. But if you would like to go on and close up and
Yep, I'll do it.
yeah, we'll go on and jump off. But thank you guys so much for logging on, and Lori, I'll let you close out.
All right, so what is employment practices insurance? It's defense cost when you're sued for any type of employment allegation. It also covers settlements and judgments. The insurance company normally provides you with defense counsel. Right now, it's very challenging for a restaurant to get employment practices insurance. So educate yourself. Prepare to talk to your underwriters. You're going to have to get on the phone and tell them what you are doing around COVID and why you are a good risk. These are sample questions that underwriters are going to ask you. You're going to need to prepare to answer all of these questions. And make sure your broker or your insurance agent is well out in advance of your renewal, because it is going to take a longer time this year to get you renewed than in years past, because all of the underwriters are very concerned about the potential for lawsuits. Ty, thank you again for inviting me to speak.
Thank you. And thank
I'll
everyone.
send this over to you, and if there are any questions, you can email them and I'll answer them individually.
Absolutely, absolutely. We would like to thank everyone. Thank you, Lori, and all those who joined us today. We have more coming later. Check it out on TRA website. Thank you. Have a great day, guys. Enjoyed everyone. Thanks.